As a court, please, my lord, just to address two issues, and the first one relates to argument advanced by almost all counsel that the common law exception of executive statement must be antecedent in nature. We submit, my lord, that that is not the only method, and in this regard, we wish to refer to the case of Rex versus Miller and another. It's a 1939 appellate division at page 106, and this, my lord, is demonstrated by the argument of Advocate Ngumalo when he quoted the Sheikh's case, indicating that the facts in question was written before the accused was charged. Looking at page 115, Author Mayor J.A. as it then was, had the following to say. An examination of the textbooks shows that there is a well-recognized rule that the acts and declarations of one conspirator are admissible in evidence against another, provided that they are acts performed and declarations made in the furtherance of common purpose. Under this rule, admissions made by a co-conspirator after the purpose had been completed, consisting of a relation or narrative of some part of the transaction, have been held to be inadmissible. Then the Learned Judge of Appeal proceeds at page 117 as follows. It is very true that one mode of showing conclusively that a conspiracy has been entered into between various persons is by showing antecedent acts, and this is what counsel have been at pains to emphasize, pointed in particular by Advocate Ngumalo. Or acts which may bring them together. But, and this is very important, Malo, but this is not the only mode. Another mode is by showing various acts subsequently in which they have concurred, acts done by them, leaving it afterwards to be inferred by the jury from the agreement or disagreement of those acts with reference to a common design, whether such common design existed or not. And just finally, at page 118, Author Mayor J.A. expresses himself as follows. If we ignore the word conspiracy and take a simple case arising in our law where A is charged as a socius in a crime committed by B, there are two elements for the Crown to prove. A, the acts done by B in the course of the commission of the crime, and B, the complicity of A in those acts. And my lord, this has been the high watermark of our argument, that the evidence of Constable Zungu shows that there was an association of the persons involved at the hostel, testified as to what happened before the departure of the accused, and also upon their return, how they followed one another. And as to what happened, accused number one handing the .38 to Gwabeni, and subsequently, while standing on a chair, announcing whether people have heard that Senzo Meyiwa has been killed. And if we take that, my lord, in conjunction with the evidence that has been tendered, in the pointings out and his own confession, my lord, the accused spells out the role that he played. He said his role was that of a lookout. We've heard the evidence of the witnesses who testify that those who were in the house, that they were in the house, two people burst into the house. They've identified at least two of the witnesses, my lord, Mizandile Kumalo, Tumela Madlala, if I get identified, accused number two. So one of the two persons who burst into the house, and accused number one spells out the role that he played, namely that of a lookout. We therefore, my lord, submit that if one looks at the evidence in totality, a picture emerges of executive statements. And then the second point, my lord, relates to the nature of the statements in question, or the status of the statements in question. Reference has already been made to the case of State versus Mhlongo. And we just wish to refer to page 333, where the court held that extracurricular admissions and confessions are hearsay by nature. Their probative value depends on the credibility of the person, the accused, other than the person who gave such evidence. And the court went on to hold that Section 3.1 of the Evidence Amendment Act codified the common law principle that stated that hearsay evidence was generally excluded. But in terms of the Evidence Amendment Act, Section 3.1 provides as follows, and we'll just refer to 3.1 subsection C. It says the court, having regard to the nature of the proceedings, nature of the evidence, the purpose for which the evidence is tendered, the probative value of the evidence, the reason why the evidence is not given by the person upon whose credibility the probative value of such evidence depends, any prejudice to a party which the admission of such evidence might entail, any other factor which should, in the opinion of the court, be taken into account, is of the opinion that such evidence should be admitted in the interest of justice. Those, my lord, are the two main legs on which the state argument rests, and we stand by the previous submissions.
Ushushiso ukuthi yena usamile ke enkulumeni yakhe ukuthi ke ngokomthetho uvumelekile ukuthi angakwazi ukuthi ke asebenzise ke lesi statement. Uyachaza ukuthi akuyona kuphela kuyona kuphela indlela eyodwa engenza ukuthi mhlambe ke kulandelelwe abantu noma ke umuntu obhekene necala benze icala ngokwenjongo ke efanayo. Njengoba sekachazile ke kwenzeke isiboniso ngamacala amaningi ke lapho ke kwakhulunywa lawo macala bese kwathathwa ke isinqumo ukuthi ke inkantolo inquma ngokuthini. Uyasho ukuthi ke kumele ukuthi sibheke ke ubufakazi lokhu ke kule cala ke isibhekene nabo ukuthi ke Constable Zungu uyewasho mayinikezela ngobufakazi bakhe ukuthi ke kwakukhona ke iqembu noma ithimba labantu ebabehlangene khona lapho basuthini hostel lapho ke aveze khona ukuthi nommangalelo wokuqala wayekhona nommangalelo wesibili nommangalelo wesithathu. Washo wachazana ngendlela ke behambe ngayo ngendlela babuye ngayo ngendlela ke umangalelwa wokuqala wabonakala ke edansa phezulu kwesitulo lapho ke esho khona noma ke ebhiyoza ukuthi ke uSenzo ubulelwe noma ke ushonile. Kanti ke futhi nesi statement asenza uma ngabe ke ehamba eyokhomba lapho egamekweni lapho kwenzeka khona isihlakalo, uyavuma naye noma ke ebufakazini bakhe kulezo statement lezo uyaveza naye ukuthi ke abantu ababili ke bangena lapho ngaphakathi kwendlu. Lokho okuqinisekiswa ke uZandile Khumalo naye ke uTumelo Madlala ekushweni ke ukuthi yebo kwangena ke abantu ababili okuwukuthi bakwazi ke ukuthi omunye walabo bantu kwawumangalelwa ke na wesibili. Uyasho ke umshushisi ukuthi ke uvezile ukuthi ke ubufakazi obuthulayo ubufakazi obulethwayo ngendlela ke yalezo statement lezo noma ke kwi confession ubufakazi vele ukuthi sizwe ngokuthi kungasiyinto esho umuntu ke ngaleso sikhathi. Ngokusho kanjalo ke usamile emagameni akhe ukuthi ke ukuyilungelo lakhe noma kusemthethweni noma ke ulandela imigomo nembandela evumelayo ukuthi ke kungasetshenziswa ke istatement somunye ke ummangalelwa.
What about the submission by Mr. Ramusipili that an application should have been brought by the state before the state closed its case? And we quoted this case of, is it Kappa?
Yes, sir.
Have you read that case?
Well, my lord, our submission is that the state presents evidence.
Yeah.
And the state may, at a later stage, rely on, it's like, pieces of a puzzle that should fit together. And the state may, at any point, rely on any pieces of the puzzle to say that the state must indicate its intention to rely on a specific puzzle beforehand, my lord. We submit that that is not in keeping with practice. We have presented the evidence. In fact, during the Section 174 application already, we signaled our intention, my lord, to invoke the doctrine of executive statements. And it cannot be said, my lord, that the state did not indicate its intention to rely on the doctrine when we clearly signaled our intention, and in fact in our heads mentioned that that is the doctrine on which we rely. We therefore submit, my lord, that should suffice.
And what about the submission by all councils that a confession cannot exist next to an executive statement because the status of a confession differs from that of an executive statement in the sense that a confession normally would be lodged or argued or presented in terms of Section 217.
Well, the court will recall that in our argument in the Section 174 application, we refer to the evidence of the case of Ditapo, which has been referred to, and the evidence of the case of Mhlongo. And in the case of Mhlongo, that has also been referred to, the Constitutional Court held that at common law, there is an exception to the exclusion of extrajudicial statements of accused. If the statement constitutes an executive statement by an accused, it may be admissible against a co-accused if it were made in the furtherance of a common purpose. And in the case of Mhlongo, it was held that the distinction between a confession on the one hand and an admission is determined by the extent to which a statement implicates its maker, and held that there is no rationale why, when used against another person, there should be a difference in the admissibility of the two types of statements. And we also refer to the case of Ditako, where in the SAA held that from the perspective of the one accused who may be implicated in the statement of another, one strains to discern a sound jurisprudential basis for the distinction. So our understanding of these two cases, my lord, is that it's really not necessary to distinguish between a confession and an admission for the purpose of an executive statement.
And then the taco, is that the case where Antahalta wrote the judgment, where there is a Tati and Moche? There were three, is that not so?
Yes, indeed.
And then
three, there were actually four.
Four, sorry.
Yes.
It was who and who, by the way?
I don't have the names of the accused. I just know that there were four accused.
No, I'm talking about the judges.
Oh, the judges.
Yeah. Antahalta was overruled
Yes.
by Tati and Moche.
Yeah, I suppose it would have been the full bench of the of the
quite.
SCA. Yes. Yes. We can quickly check who was on the bench.
Now I know Antahalta wrote that judgment.
Yes.
Hello? You got it?
I've got it.
Yeah.
It's
Who
Nafza.
who are the judges there?
Judge Nafza.
Hello?
Nafza and Ponan.
Nafsa and Ponan, okay.
Yes.
It's not the taco. Let's see. Yeah. No, I'm quoting the wrong one. It happened in...
Northwest.
Hello? Northwest, ne?
Yes, in Northwest.
Northwest.
Yes.
What's that, Moremio? The teacher who was
Yeah, around the town.
who reneged from his declaration. Why don't you seek with your computer, Antahalta, Moche, and Tati? SCA.
That will be Judge Makok.
Hello?
Judge of Appeal Makok, I think that's.
Was it Makoka?
Yeah, I think that is.
Yeah, Tati is Makoka, is it not?
Yes.
I thought Tati, that's why I know this.
The quorum was Supreme Court judges Nafsa, Ponan, Leach, Pense, and Swan.
Okay. Okay, fine, I'll have to check for myself. You say that one, what's the title of that one?
This one, Lord, it's the citation is Moses Moshe Ditako spelled L-I-T-A-K-O.
Right, it was in the Northwest, that case. Rustenbeck, if I recall.
Yes, in Rustenbeck.
Yeah. So you say that citation is who? Hunan and?
It's Nafsa, Ponan, Leach,
Nietzsche.
Pete, Judges of Appeal, and
Yeah, Peter.
and acting Judge of Appeal, Swan.
Oh, yeah, Swan. Okay.
And it was heard on the 7th of March 2014, delivered on 16th April 2014.
All right, fine.
Yeah. It was, the trial took place in the Rustenburg Circuit Court,
Right, yeah.
And it was an appeal from the Northwest
Right, yeah.
High Court. Yes.
Okay. I spoke to some colleague in the SCA, but we can't wait for them. Apparently, there's an appeal on the same legal basis. This colleague of ours says he has written a judgment. I didn't want to read it because he says he's waiting for his three colleagues to assent or to tell him he's joking. Yeah, anyway, fine. I don't think we'll wait for him.
On which subject, my lord? Sorry.
The very subject.
Oh.
Executive, blah, 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 blah. The very same thing we're doing here.
Oh, okay. Yes.
No, I won't wait for him. I'll reserve judgment until Monday then.
As a court.
Unless somebody wants to add something else. We are done. Okay, fine.
That next week I'm asking the indulgence to be excused.
So you won't be there on Monday?
Yes. But Mr. Ngumalo is standing.
Okay, fine. All right, let's adjourn until Monday.